Hi. So, welcome to our new series on business and corporate law fundamentals. In this series, we are going to be taking you straight into the courts and look at various judgments involving how businesses, directors are held liable for the decisions and losses or debts that their companies are engaged in or incur as a result of their operation. We are going to be seeing throughout the series how a landmark judgment at the Supreme Court in 1999 to 2000 in the case of Moko and Kuma sets the precedent of how we handle corporate personality and personal liabilities of directors. We are going to be covering various court cases from the banking sector cleanup exercise, various issues currently pending on issues in respect of the ZPay CEO and what ZPay is going through and how corporate liabilities are coming in. Because one of the things that you must understand is that limited liability companies are their liabilities are limited to the capital of the company. And so directors cannot be held accountable for the loss, decisions, or any illegality that a company engages in because of the corporate veil. But there are circumstances under which the corporate veil can be pierced. And when that happens, it means the company and the directors, the founders, the CEO, the managing directors will now be held accountable for the entity's operation. And throughout this series, we are going to be bringing out various cases to help us understand how this actually is. And the impulse of this is to provide you with some education to let you understand that it is not just about starting a business and registering the business as a limited liability company. It is not only just about saying that, okay, I have a limited liability company. No matter what I do, I'm not going to be held accountable because the liability of the business operation is limited to the company. In addition to that, the objective is also to help you to have an understanding of the best practices that you must use as an individual going into business, and most importantly, setting the tone for us, especially those of you in the ICAG professional qualification examination, to have an understanding how these incorporate into the various decisions that companies make, because you can't be held liable for the decisions that you make for the companies if it is identified that there is some level of dishonesty, fraud, or some confusion, and there is no separation or clear separation between owners and then the shareholders as well as the managers and the company, then you will be held accountable. And that is what we are going to be covering throughout the series as we touch on various specific cases. On today's episode, we are going to be looking at the classical case, that is the Republic versus Bernard and Chibuisiako and Akunta Mining Company Limited. This was a case that is very significant because of the person involved, and also for us to learn about the issues that we mentioned, the separation of ownership from the owners, from the management of the company, and how the circumstances under which the corporate veil can be pierced. This case was at the High Court of Justice, Criminal Court 4 in Accra. Judgment was delivered by Her Ladyship, Justice Audrey Kokuvi Tay, on the 20th of July, 2026. And this is a classical case because a lot of issues have come up in respect of this case. But what we want to do in this particular episode is to go through the thematic issues that we must understand, and most importantly, talk about that corporate veil issue and why Bernard Entry Boesiako, who we all know as Wontumi, is held accountable for the decisions and the operations of his company, Akonta Mining Company Limited. So let's start the journey by looking at the accused parties and the 6 counts indictment. So we have accused person 1, A1. This is Bernard Chibuesiako Wontumi. He's a 49-year-old entrepreneur, owner, and controlling director of A3. Now, A3 is Akunta Mining Company Limited. Now, I want you to be mindful of the terms because we are going to be referring to them as we go. So, A1 is Bernard Chibuesiako, that is Wontumi, and then A3 is his company, Akunta Mining Company Limited. And so here he pleaded not guilty So he's the owner and controlling director of Akonta Mining Company Limited. He pleaded not guilty. The second accused person is Kwame Enchi at large. What does that mean? Did not appear in court. He's regarded as a shareholder or a director of the company. Then certainly the third is Akonta Mining Company Limited, incorporated on the 5th of November 2010. And the object of this entity was to be engaged in mining and exploration. So these are the things that we must understand. Now, there were other accused persons. However, some of them switched allegiance in a plea deal with the prosecutors, that is the Attorney General of Ghana, to then become witnesses, prosecutor witnesses, to help them in advancing their case. And so that is why we have these three people. But what is the issue? So there are 6 counts in total. Count 1, 2, 3 involve assignment of mineral rights without approval. We'll come back to this because the law, the Mineral Act 703, states that if you have a mineral right and you are going to assign it to someone else to work on it, whatsoever be it, you need an approval from the minister. So assignment of mineral rights without approval, that is count 1, 2, and 3. Then count 4, 5, and 6 is purposely facilitating an unlicensed mining operation. Purposely facilitating an unlicensed mining operation. So in total, 6 counts broadly divided into these areas. But where did this all start? This started because of the anti-galamsey sting in the Samaraboy forest. So between 16th and 17th April 2025, Samaraboy forest, that is A3's concession. Remember, A3 is the Akonta Mining Company Limited. So Samaraboy's forest, A3's concession. The arrest, Michael Jedu Eyisi, PW1. PW1 will mean prosecutors witness 1. And 28 others found occupying a structure boldly branded with A3's name. Again, boldly branded in Akonta Mining name. What were the assets they seized? 25 excavators, 25 serviceable, 8 pump action guns, 1 single barrel gun, 210 cartridges, 4 motor bicycles, 2 vehicles, water pumping machines, 157,000 in cash alongside suspected gold. So these were the things that they seized. Why did this thing happen? Let's go. At the third level is the boss, that is Bernard Nhyira, A1, okay, accused person 1. Then PW2 confessed to a September 2024 arrangement allowing him to enter the concession. So another person, P2, prosecutors witness 2, says that, hey, in September 2024, I had an arrangement with Bernard Nhyira to allow me to enter into the concession owned by Akonta Mining. Second level is the supervisor, Henry Okum, identified by PW1 as the employer. And so now we have prosecutor witness 1, prosecutors witness 2, all who are having related engagement with Akonta Mining, now saying that, hey, listen, I understand, I know. 3, level 1, the grounds. Michael Jedu Eyisi, PW1, and the 28 others. So these were the people arrested on the ground. And so let's come to the main issue here. What was the legal battleground? What was the main issue? There were 2 conflicting narratives of intent, because in any criminal case, intent is crucial. So it has to be established. So there were 2 conflicting narratives of intent from the public case, that is the prosecutor, and from the defendant's case as well. So let's look at it. The prosecutor says that, hey, listen, there was an illegal mining and arrangement. What was the argument? They said A1, that is Chairman Wontumi, granted PW2 access to mine for gold on unmined portion and reclaim devastated areas. So this is what the state alleged, that, hey, Chairman Wontumi allowed another person, and we're going to look at PW2 in a moment, to go and mine somewhere that he hadn't mined yet, and also to reclaim devastated areas. Who funds that reclamation? Because every mining organization that is given a mining license, every person given a mining license, you're supposed to reclaim, restore the environment to how it was. So who is going to fund that? A1 expected PW2 to fund the reclamation works using proceeds from the illegal mining operations. So this was the state's argument, that Chairman Wontumi gave the site out to somebody else so that they can mine, and then the proceeds from that, they will use it to do the reclamation of the site. So it means the state is saying that Chairman Wontumi did not pay for the reclamation, but then the person employed to do the reclamation is supposed to fund the reclamation from engaging in illegal mining operations. What was the defense of Chairman Wontumi? The argument: permission was strictly and exclusively for land reclamation, specifically planting coconut seedlings. So Chairman Wontumi is saying, yes, I engage PW2. And I said, yes, go there, but I want you to reclaim the site. I want you to plant coconut seedlings. I didn't ask him to go and engage in any illegal mining. I didn't give my mining rights to him to go, or I didn't allow him to go and mine in that concession. I didn't ask him, but I just asked him to go reclaim the place by planting coconut seedlings. So A1 absolutely denies granting permission to extract minerals. But there is an undisputed fact that we need to understand, that one, A1 permitted PW2 to enter Akonta Mining's concession. So that was the fact that, yes, you said the person should go and do land reclamation, plant coconut seedlings. Okay, we believe that you didn't pay the person and you wanted the person to engage in some illegal mining operations and use the proceeds to do the reclamation. But you said no. But we cannot deny the fact that you allowed the person to enter your concession. That one is an undisputed fact. So this is the argument. Primarily, the case brought against Chairman Wontumi, for which he has been jailed for 20 years, currently pending an appeal because the lawyer said they're going to appeal it, is this issue. Now let's calm down. Let's establish the parameters, because it is important. You cannot just come. The Attorney General couldn't just take this to court and say this thing and go away. So we need to establish the issue. So let's look at establishing the parameters of judicial scrutiny. The burden of proof, because you need to prove beyond reasonable doubt. And so in proving beyond reasonable doubt, there is a legal precedent rooted in Wellington versus DPP and codified in Ghana's Evidence Act. That is NRCD 2323. Judicial definition: relying on Lord Denning in Miller versus Minister of Pension, it requires a high degree of probability, but the law will not admit fanciful possibilities to deflect the course of justice. So you have to prove beyond reasonable doubt. You cannot just come and say, oh, Chairman Wontumi gave permission to somebody and the person is doing illegal mining. You got to prove something. Okay, so how do we prove it? So let's come to count 1 and count 3. Assignment without approval. Section 14, clause 1 of Act 703 states that a mineral right shall not, in whole or in part, be transferred, assigned, mortgaged, or otherwise encumbered or dealt in a manner without prior approval in writing of the minister. And so count 1 and count 3, assignment without approval. This is the act. So you cannot assign without the minister's approval. And so there are 3 elements here that we need to be mindful of. which the state has to prove. One was prove that the act was done without the minister's prior written approval. Because remember, we have had an undisputed fact that PW2 has been permitted to assess the consignment of A3. So now you got to prove that they have assigned the consignment without the minister's approval. So one, prove that the act was done without the minister's prior written approval. Okay. Two, prove the accused person dealt with or encumbered the mineral rights. Number three, prove the accused person is the true holder of the rights. So these are the three things. And so here, the Republic must prove all three ingredients beyond a reasonable doubt to secure a conviction. So it is in the hands of the Attorney General to prove that, yes, Chairman Wontumi owns the right. Yes, Chairman Wontumi permitted somebody to assess the concession illegally. And three, that Chairman Wontumi did not obtain written approval from the minister. The state has to prove all three to be able to prove beyond reasonable doubt if they want a conviction. So let's look at the elements one after the other. Element one, it was proven. Per the judgment, Her Ladyship said this was proven. The missing ministerial signature. Okay, so core finding. The requirement for written ministerial approval is the least contested element. Both A1, which is Chairman Wontumi, and A3, the company, Akonta Mining, admitted to not having approval implicit in their denial that they permitted mining at all. So they accepted that, no, there was no ministerial approval. Okay. So what does this mean then? Expert testimony. Witness. Joseph Iroko, that is prosecutor witness 4, Minerals Commission expert witness. Defense counsel. In your records at the Minerals Commission, do you have any such application by A3? PW4, not to my knowledge. Defense counsel, I want to put it to you straight that A3 has never applied for a transfer. PW4 replied, no, my lady, they never applied. So the first test, ministerial approval before any transfer is done, was not sought. And so Her Ladyship was justified that this has been proven beyond reasonable doubt. Element number 2, that was also proven, breaching the principle of exclusivity. What does this mean? Legal defense, that is the encumbrance. According to Black's Law Dictionary, the right is encumbered if a subsequent right or incident is inconsistent with its employment. What was the proof? Exhibit G. The mining lease agreement dated 23 July 2021 grants A3 the exclusive right to work, develop, and produce the mineral in the leased area. The court's conclusion. Because the mining right is exclusively A3's, permitting PW2, which is a third party, to exercise rights in the same concession is inconsistent with A3's exclusive enjoyment. Therefore, granting PW2 access legally constitutes an encumbrance of the mineral rights. So you cannot go take mineral rights and then allow a third party to come and have access to that as well. No. That is why the law is that before you transfer the rights you obtain, the concession you have to somebody else, the minister should have given you a green light. So this second element of exclusivity, that was also proven as per the ladyship, Her Ladyship's conclusion, proven beyond reasonable doubt. But here is the play. Now there is that contention. So Chairman Wontumi, A1 is saying that, hey, yes, I gave the person the permission though, but I didn't ask the person to go and mine. I told the person to plant seedlings to reclaim the land. But you, the prosecutor, you are alleging that I gave the person to reclaim the land, but I didn't give the person any money, and I told the person to go and mine and use the proceeds to fund the reclamation. And so you have to prove that. And this is where circumstantial evidence comes in, because there is no document detailing out the terms and conditions surrounding the arrangement. It was just a verbal arrangement. It was just a verbal agreement. If Chairman Wontumi had signed any document with the third party, PW2, then that document would have become evidence in court. But because it was just a verbal agreement, there were no witnesses. Now we have to, her ladyship has to look at the thing that the prosecutors are saying and the defense of Chairman Wontumi to establish who is right and who is wrong. This is where the concept of circumstantial evidence comes to play. So that we will find out, is the prosecution lying or the defense lying? Who should we take? Whose word should we take? Now, one thing you must understand is that circumstantial evidence arises in many cases, especially in verbal agreements and various things where there are no supporting evidence. Circumstantial evidence is going to be used to reach a conclusion and adjudicate the matter. So, circumstances of guilt, exposing the true intent. So, how do we establish this? So, number one, fact number one, the actor. PW2 is a commercial small-scale miner licensed since 2017 with zero background in agricultural reclamation. Okay. So, Chairman Wontumi, you are saying that you gave PW2 the place to reclaim and plant coconut seedlings. But this person you told that was the only thing you asked him to do. Holds is a small-scale miner, and he is licensed since 2017, and they have zero background in agricultural reclamation. Fact number two, the cost. Defense witness one, which is the defense expert, testified that land reclamation is a highly specific, costly endeavor. So reclamation of a mining site is not something that you just walk and do it anyhow. It's a very costly thing. So that's fact number two. Then we come to fact number three, the funding. Because remember we spoke about the funding, right? Yes, if you are telling PW2 to reclaim the site, plant coconut seedlings, who is going to bear the cost? A1, Chairman Wontumi, admitted he provided absolutely no money to PW2 for this expensive reclamation work. So how do you say that you gave the site to somebody and the person is supposed to plant coconut seedlings and it is part of your reclamation, but you didn't give the person any money? So on what grounds is the person planting the seedlings? Like, how? And this is it. And so her ladyship applied a precedence of the Dewar and the Republic test for circumstantial evidence must lead to an irresistible conclusion incompatible with innocence. And so based on that, the conclusion of her ladyship was that there is the irresistible conclusion that was reached is this: it defies logic that a commercial miner would volunteer to do expensive land reclamation for free. The only rational conclusion is that A1, Chairman Wontumi, permitted PW2 to extract gold to fund the reclamation. A1's coconut planting defense is rejected as an aftermath thought. So this is the case. This is how her ladyship concluded on the concept of that exclusivity and said, hey, listen, yeah, I get what you are saying though, but you didn't give the person any money for the seedlings. If you had paid for the seedlings, you don't have any contract also here, because somebody with a mining license cannot voluntarily come and plant seedlings for you for free. Like, who does that? Who does that? I hope you are getting the thought here. And because of how sensitive this matter is, I want you to make sure that you take away your emotions to understand the facts of the case. Okay. Then we come to element 3, which is the corporate facade of Akonta Mining. The issue about board of directors, the objective. While A3 holds the physical lease, which is Akonta Mining holds the physical lease, the Republic charged A1 as the owner and controlling director. To convict A1, the court must address the doctrine of separate legal entity, Solomon versus Solomon. Because Chairman Wontumi doesn't own, right, a lease, a mining lease. It is Akonta Mining that owns a mining lease. So if Akonta Mining is now involved in giving the permit out, then Akonta Mining should be responsible. Yes, Chairman Wontumi did the arrangement, but you cannot charge Chairman Wontumi for entering into a contract on behalf of the company when something goes south. And so then we have to establish, is it possible that he acted just on the behalf of the company? Is that a separation or not? And that is where the doctrine of separate legal entity comes in. Here was the evidence. The ghost directors. A2, Kwame Enchi, has been missing from the jurisdiction since 2021-2022. A1 testified he has not heard from him. No compliance. A1 could not remember the last time A3 filed annual returns with the registrar of companies. So they've been in operations, but Chairman Wontumi could not remember the last time Akonta Mining filed annual returns with the registrar of companies. So at this point, you are seeing the various issues opening up. Then third, undocumented dealings. A1's massive arrangements regarding the concession were entirely verbal. 4 defense witnesses confirmed no writing contracts existed. So at this point, the case is getting to a point where it is going against, it is not being in the favor of the defense. The reality. The court found no functioning board or executive officers. A1 alone was the controlling mind and hand of the company. So there was nothing like board of directors. There was nothing like executive officers of the company. They didn't enter into contract. Things are not being done. So it's more or less like, media, that kind of vibe, right? That kind of vibe. So this was the corporate facade, how Akonta Mining is. There are no board of directors. They have not filed annual returns with the register of companies for a long time. Because if you cannot remember, it means that's a long time. And number 3, there were various dealings that were not put into contracts. Now, what's the lesson here? It means that you cannot have a company, running a company without documenting things. Verbal agreement is good, but documented evidence is crucial. Because sometimes people can enter into what is referred to as gentleman's agreement or handshake agreement, where people just shake hands over a deal and walk away. No. You can shake hands, but you got to sign some papers at the end of the day because of future issues. And so let's bring the discussion home. Piercing the veil, shattering the legal entity defense. Because Akonta Mining is the one engaged in this. Why Chairman Wontumi? Now hear what happened. Legal precedents, that is the Moko and Kuma, which dictates the corporate veil can be lifted based on peculiar factors of a case to do justice. Now, this was the case I referred to at the beginning, the Moko versus Kuma. This was in 1999-2000. The case traveled up to the Supreme Court. The whole issue was that Moko entered into a contract. She was the managing director and the CEO of a company, entered into a contract to buy some product from Kuma. At the end of the day, Her company could not pay the debt, and now Kuma is suing the company to pay the debt and Moko as well. But when this thing went to court, the Supreme Court, it traveled to the Supreme Court. So the ultimate ruling was that Moko was the managing director, signs the contract on behalf of the company, and there was no intention of fraud, dishonesty, that she was signing that contract and then the company will not pay. So she didn't have any direct benefit, and so she was supposed to work free, because a registered company is a distinct legal entity separate from its shareholders, directors, and managers. But there are exceptions to that. Which is also emphasized in the Companies Act 2019. And so that then provided some guidelines to her ladyship to reach some conclusion to say that when you go to Samra Boy, nobody knows Akonta Mining Board of Directors. What I know is that Chairman Wontumi owns Akonta Mining, and Akonta Mining is Chairman Wontumi. So the court final findings. The court pierced the veil, ruling there is no difference between A1, Chairman Wontumi, and A3, Akonta Mining. Therefore, A1 is the de facto and true mineral rights holder of the concession. The third element now proven. So remember where we started from here. That number one, you got to prove that the act was done without minister's prior written approval. You got to prove that the accused person dealt with or encumbered the mineral rights, gave it to somebody else to occupy. Then number three, you got to prove that the accused person is the true holder of the mineral rights. All three must be proved. And yes, the third one is where the corporate veil issue comes in. So really, although on paper, the mineral right is owned by Akonta Mining, bearing the fact that we don't have functioning board of directors, the Chairman Wontumi is regarded as the de facto and true mineral right holder of the concession. Now let's come to count 4 to 6. Facilitating unlicensed operation. Facilitating unlicensed operation. Section 99, Clause 2B of Act 703 states that a person who acts or instigates, commands, counsels, procures, solicits, or in any manner purposely aids, facilitates, encourages, or promotes any act in contravention of the provision of this act commits an offense. And so the 4 checklists here. 1, contravening the act. Another person engaged in an act contrary to the law, because PW2 doesn't have the license to engage in the mining. So he that person contravenes the act. 2, absence of penalty. The act does not specify a specific penalty for such contravention. 3, abatement. The accused aided, facilitated, or promoted the act. Checklist number 4, purpose. The abatement was done purposely to breach the law. And so on this background, Section 99, Clause 2B of Act 703, facilitating unlicensed operation, boom, there is an issue there. So the regulatory trap. The defense becomes the confession. So let's look at the regulatory reality. Section 59 and LI 5174, any person providing land reclamation to a mine must be licensed as a mine support service provider. So remember, PW2, who Chairman Wontumi said, I asked him to do reclamation. I asked him to go and engage in planting of coconut seedlings and not to go and mine. The law is that is a mine support service provider and you have to be licensed. But remember, PW2 is a licensed small-scale miner, not a licensed mine support service provider. You get a flow here? Then the next one, the checkmate. By A1's own written admission, he purposely facilitated P2 to undertake reclamation. P2 had no LI 2174 license. So how do you tell somebody to go and reclaim your land, plant seedlings, who doesn't hold a license to provide that services? You didn't pay the person anything because you admitted you haven't paid the person anything. How does that happen? So that was the checkmate. Then the defense alibi. We only did reclamation, not mining. So, yeah, you've been allowed to go and do reclamation, you didn't do mining, but you don't even have the license to begin with. So this was the regulatory trap. So you can defend and say, yeah, he asked the person to go and do reclamation, but the person who he asked to do reclamation doesn't have the license. Okay, the person only did reclamation. The person did not mine. So there is no illegal mining operations. The person was not paid. So if the person was not paid, how would the person take on free reclamation exercise without pay? So the only conclusion is that, as we established earlier, that it's highly probable that he was asked to engage in some activity, get some proceeds, and use part of the proceeds for the reclamation. Conclusion. By attempting to use reclamation as a defense, A1 formally confessed to purposely facilitating an unlicensed mining operation under count 4 and 6. Here is the play of the case. And so, final judgment. There were some questions. So, number 1, was the concession incumbent without ministerial approval? Finding, yes. Admitted by defense and confirmed by mineral commissions. Offense address 1 and 3. Question number 2. Did the accused intend for illegal gold extraction to occur? Finding, yes. Proven via circumstantial evidence. Dia versus the Republic. The reclamation alibi was economically illogical because you did not pay the person anything. How will the person engage in the reclamation if you didn't pay him any money? This addressed count 1 and 3 as well. Question number 3. Can A1 be held personally liable for the corporate entity's actions? Can A1 be held personally liable for the corporate entity's actions? Finding, yes. The corporate veil of A3 was pierced due to total lack of governance. Akonta Mining is Chairman Wontumi. And this offense addressed count 1, 2, 4, and 5. Final question. Did the accused purposely facilitated on an unlicensed operation? Court finding, yes. Even under the defense's own alibi, permitting unlicensed reclamation violates LI 2174. And this addresses count 4 and 6. So the Republic successfully met the Wellington burden, proving all elements beyond a reasonable doubt. The constitutional and factual defense failed. This was the outcome of the Chairman Wontumi's case. Now, the case is not over because his defense is preparing for a court of appeal, to go to the court of appeal. And what is going to be happening is that the judgment may be set aside, bail may be requested, and all that to allow the case to travel. So we are in for a long haul. But at this moment, this is where we are. And so what are the key takeaways here? Number 1, Akonta Mining owned a mining lease. Number 2, Akonta Mining doesn't have any working executives available. So there is no separation between ownership and managers, because the only person that can be associated with Akonta Mining is Chairman Wontumi. So there are no board of directors, no nothing. Number 3, Akonta Mining has not submitted annual returns to the Register of Companies for a long time. Number 4, the de facto rights owner, as per the judgment, Chairman Wontumi, permitted another person to have access to a concession owned by Akonta Mining. Number 5, allowing somebody to reclaim a mining land without license, because they must have mining support service provider license as per LI 2174, is an offense. The next takeaway is that the agreement was not documented. What does that mean? It was just a verbal agreement, a gentleman's agreement. Hey, I'm engaging you to go and reclaim the land. The next takeaway, there was no payment for the service. So even if you gave the contract of reclamation to a company that doesn't have a license for reclamation, you didn't pay him any money. You didn't pay them anything. And so how can a person come voluntarily and say, oh, mining site, I've asked him to reclaim the place, plant coconut seedlings without paying anything? How is that possible? And the next takeaway is that although everything involved is in the name of Akonta Mining, the evidence available suggests that the rightful owner of the company and the only person that can be really associated is Chairman Wontumi. And these are the things that we must understand in respect of this particular case. And so as a business owner, as a young entrepreneur coming, there are a couple of things that you must understand. That the mere fact that you register a company as a limited liability company does not mean that you can go about and do things anyhow. You have to ensure that you are operating within the ambit of the law. Number 2, ensure that whatever contract you enter into, because it is your company, it has to be in contract. It has to be in writing. That's the thing. It has to be in writing. And make sure that you enter into contract with people who have the requisite qualification, license to be able to do what they are supposed to do. If not, it will come back, and although there is a separation between owners, managers, directors, and the registered entity itself, as established by the Supreme Court in the Moko versus Kuma case, the veil can be pierced if it is identified that there was some intent of misleading, fraudulent activity, illegal activity, and you, the owner, may be held liable for the wrongs, actions, decisions, undertakings of the company. Let me hear from you in the comment section. What do you think about this subject matter issue? If there are any other cases that you want me to look at in detail and see how practically we can apply that, put them in the comment section for me. I'll be excited to look at them as well as we continue in this series. So if you learned something from this video, remember to like, follow, subscribe, and share the video so that others can also see this. Most importantly, let me hear from you if there are any questions you have, or if you have any topic that you would want me to cover on the next episode, leave it in the comment section. I want to read from you. If you want to enroll as well in our courses to study under my mentorship for your ICA, ACCA, SEMA, or ICANN examination, you can head on to our website, NhyiraPremium.com, or download the Nhyira Premium mobile application on the Google Play Store or the App Store to complete your enrollment. You can also send us a message on WhatsApp or call us 050-114-9296. 050-114-9296. Complete your enrollment today to join our community. Let me hold your hand, provide you with the blueprint that you need with the team here. Let us assist you. This is our mission. This is what we do. This is what we are called for. And we have the resources, the skills, the expertise needed to help you to pass the examination. So visit our website, nhyirapremium.com, to read more about us. Or better still, download the Nhyira Premium mobile application on the Google Play Store or the Apple App Store. You want to get personal? Hit us with a DM or send us a message on WhatsApp 050-114-9296. Thanks for watching, and I'll see you on the next one.